hanging around longer?
I really don't. I know I go to various courts probably every 2 or 3 years, and the thing is you put the pressure on both the state and defense to either try the case or resolve the case. Some people have the philosophy, if the case goes on a trial list, it goes on the list, and it's called in chronological order. I learned from Judge Kinney, who really started the whole process back in the middle 80s, that if I get a lawyer who comes to court on a certain case and we pre-try it and the person's out on bond, the lawyer thinks the person is set on bond forever. And if I get a judge available before that lawyer is back in his office, he's back in court the next day to try the case. The threat of trial makes people see reason to resolve cases. I don't have an exact answer to your question.
Yeah. And how about like in like the Hartford, New Haven, Bridgeport type, with the large urban GA type courts? What is it for the cases that actually end up going to trial in a GA? As a general rule, about how long between the time of arrest and the time the trial actually gets started, typically, would you say?
Anywhere from 8 to 14 months.
And I think a lot of people were surprised to find out that very few cases actually in the GAs go to trial, right? Virtually everything is resolved without a trial.
When I was in New Haven, I always tried to keep one GA case on trial. The problem is, the way our system has evolved over the years, the GA court has become more of a social action court. 90% of the people there are just individuals trying to make it every day of their life. 10% are the so-called bad individuals. The real bad ones end up going to Part A. You get some young prosecutors and they have a case which you know is not going to furnish any business, and they won't resolve that case. They start picking a jury. Witnesses don't come in and the case goes away. But you put them on trial and they fold up right away because of lack of witnesses around or whatever. But cases in the GA do go to trial.
But it's just, in a place like New Haven or something like that, how many would you estimate each year results in a verdict? Trial?
Maybe only six or eight tops.
Yeah. I think most people find that surprising because there's I think 20,000 or so cases coming in the door every year.
Well, they take in about, New Haven, about 1,000 cases a month they take in.
But, okay.
Yeah.
I think it's 20,000 if you include all the various motor vehicle type charges.
I'm not counting,
yeah.
You're right,
Okay.
I'm not counting motor vehicles, sir.
And the final thing I want to ask about, as you know, a couple of years ago we made a whole assortment of reforms here focused on repeat, especially repeat violent offenders, and in the general category, which is sometimes referred to as 3 strikes and you're out, in terms of upping the penalties for persistent offenders and requiring certain findings to be placed on the record as prosecutors are charging people who might be eligible for that. Is that working there, Judge?
I got it now.
Okay. And I'm just looking for an update. Do you have a sense that has any impact whatsoever, either in the plea bargaining or the sentences imposed after trial? Are the prosecutors making the necessary statements on the record as to whether or not let's say someone coming in charged with assault 1, do they have previous convictions? Are they eligible for the persistent offender thing?
As far as that, based upon the legislation passed by the legislature, when I arraign a person with that certain type of a crime, I ask the state's attorney if they qualify as a persistent dangerous felony offender, either for 2, to have an enhanced penalty, or for 3 strikes to have a hearing and probable cause. And the state's attorneys are very good about that. Now, as far as the penalties, sometimes it can be misused, like you pass the home invasion statute, which carries a mandatory 10 years in jail as a Class A felony. You see some overzealous prosecutors where I break into my girlfriend's house to get some of my personal items out of there at night. They charge me with home invasion. Now, I know it's a crime and the man should go to jail, but should he go to jail for a mandatory 10 years? I mean, if he has no prior record, he jumps from 0 to 10. So sometimes you might see some that abused a little. But no, as far as the laws you passed, I think they were needed and they're useful. And
is it your sense that for the worst of the worst, let's say the real predators, whether it's in the GA or the JD courts, do you get a sense that they're getting longer sentences now as a result of that?
Yes.
Okay. All right. Thank you. Further questions? Senator Kissel?
Thank you very much, Mr. Chairman. And you asked most of the questions I was interested in. Judge Damiani, it's great to see you. Thank you for all your years of service.
Thank you.
I just wanted to just sort of inquire of you, especially regarding your work in the GAs, where you had sort of characterized it as 90% social work or
Social action.
social action. Given the fact that we've been in this deep recession now for almost 2 years, and I had indicated to I believe it was Judge Bishop, that, for example, recently one of my police chiefs in Enfield, Carl Sferrazza, said, you know, crime, drugs is always a big generator of crime, but now we're seeing a lot more things associated with money, whether it's embezzlement, just bank robberies, whatever, and there seems to be a large uptick in that area. From your vantage point regarding the ebbs and flows of criminal activity in the state of Connecticut, both in the, like a GA 14, and you know, where you get the Part A's, and in the other GAs that might have the social action elements, have you seen a change in what's coming before the court system?
You've seen a lot more embezzlements. I mean, people in Waterbury now, we have a lady who worked for the Seven Angels Theater. I mean, people who just are hard-pressed to pay their bills, out of work, mortgages being foreclosed. They look into other people's pockets for the resources to pay their bills. So you see a big uptake as far as embezzlement is concerned, I think. Robberies, bank robberies are on a spree. We had them when I was in New Haven quite a bit. People just walking into banks and handing notes. I think that was a result of a recession. You're getting people who are just GA kind of people, minor league, shoplifting, things like that. Now they needed more money. They've graduated to walking into a bank and passing a note and asking for money from a teller. So the recession has had a direct impact, yes, sir.
And do we have the resources to handle those, not necessarily with the police departments and their investigations, but with the state's attorney's office and the ability to bring them to trial?
Yes. State's attorneys do a good job throughout this. Well, the 4 places I've been, Bridgeport, Hartford, Waterbury, New Haven, the other places I think are just as good.
And the last question, I thought it was sort of heart-wrenching, the story that you indicated where you had that young lady that was 17 years old, and but for the lack of any kind of resources to treat this individual, you have to keep her incarcerated for 4 months until she turns 18. I mean, what a birthday present. To my mind, I understand we have a $500 million deficit, and we're looking at a huge hole in the next 2 fiscal years. It's going to be worse before it gets better. But there will be some kind of budget, and part of what we're about here is just trying to prioritize and figuring out where we get the best value. And, you know, I got on my soapbox before, but I'll do it again. I think that if we break the cycle of recidivism, especially for young people, we have less victimization and we have more tax-paying citizens that can help this state survive. What are we failing to do, or what is the biggest area that we should address, given that we lack resources? But if we had a magic wand and we could pick one area to do better in, what would help you, especially with these young people?
You know, a question was asked to Judge Lander before, and he talked about the urban juveniles as opposed to the ones in the inner city. And even domestic violence, it comes down to resources to educate the young people. I mean, as far as this young girl, also a breakdown in the family. This young girl had no place to go. She had a grandmother who didn't want her, and she was living with some 33-year-old man in the hill section of New Haven, and the grandmother wanted to send her back there until we found a place for her. And I said, I'm not sending her there. Do you know who this guy is? She knew the guy by a first name. And so this young girl is going to take a bed in Niantic. It costs us $50,000 a year to house an inmate in a prison today in Connecticut. So she's taken 4 months of a bed where a violent offender, be it a woman, could have used that bed. So magic wand, yeah, we need more money. Need more programs, halfway houses, residential facilities, drug treatment facilities, residential. Need money for it.
Well, it sounds very similar to what we're trying to do with our aging population. And by that I mean, traditionally Connecticut has used...
About me, you mean, aging?
No. Oh. Traditionally we've used nursing homes, and we're trying to have more home care, which is better for the individual and less costly for the state. But it's very, Connecticut land of steady habits, very difficult to make that transition. And I believe what we need to do as a state, and nationally we're regarded very well in this regard, but we have further to go, is as much as I've got 6 correctional facilities, and I'm a champion of my corrections officers, the men and women on the front line, there is a role for our prison system. Just this morning I toured Osborne, quite an interesting slice of life going through there. Got to commend them all for dealing with those individuals. But at the same time, we haven't made the appropriate leap, I believe, to those other total incarceration mechanisms, the halfway houses, the treatment, and all those other things, which dollar per dollar is less expensive and has better outcomes when we look at breaking the cycle of recidivism. So it's something that I'm just going to keep harping on over and over and over. I know we don't have the money to do it all, but we need to redeploy the limited resources we have. And I actually believe it's less a case of having the best criminal justice system that we can attain. While I do believe that's part of it, I think it's about our state's survival. Because I don't believe we can afford to lose all those young people in the long run. So I've said it twice now this afternoon, and I try not to say it anymore, but I appreciate all your hard work in the criminal justice field.
Thank you very much, sir.
Thank you. Over here.
I'm sorry.
Yeah, we went through the confusion problem with the
Judge
circular.
Lander, but I'm a lot smarter than he is. I should have caught it.
And you had the opportunity to see him go through
That's right.
it. A couple of questions.
Yes, sir.
Actually, 3. The first one, similar to what I asked Judge Allender about before. It seems like the option that's facing the Appropriations Committee, to some extent, I'm not sure how much control we have over the decisions the leadership of the Judicial Branch makes, but the alternative to closing the libraries has been put forward by some librarians is to do what they've done in the past and just don't update the services. And I was wondering what you thought of that, as how you would feel about going into a law library and looking at a book which may or may not be up to date or could be 5 years
Judge
old.
Lander had the answer, and the lady over here just said it also. What's the point? When you walk into a library, you expect to have the latest material there in a certain point of law. The problem is that if we did that, the judge, when I was growing up, the judge was supposed to be the smartest individual in the courtroom. Now, if judges are going to outdated libraries, when we walk into court, we're at a disadvantage to these high-priced lawyers who have all the books they want. So I'd rather see them close the libraries and just have an antiquated library in place.
Okay. Second, you mentioned that there seemed to be an uptick in the number of embezzlements. And I'm just wondering if it's that people are more willing to bring them forward, or because there were some high-profile ones. I'm sorry about the cell phone. I forgot to turn it off. It'll die a moment, maybe sooner. And there have been some high-profile cases that have made pretty big headlines involving some banks, for example, in Waterbury, which is where I think you said you were sitting. And
Yes.
And I think there were a couple of other cases where some prominent institutions seem to have been the target. But I'm just wondering, is that what you're referring to, or are you seeing a steady
No.
stream of little $5,000, $10,000 embezzlements?
Steady stream of 35, 40, 45,000, 50, in that range there, from their employers, lawyers, doctors, accountants, things like that, working for a company where they have some person in charge of writing checks or whatever. And you see them in a couple $100,000 also. But there's the realm really is 45, 50, 65,000, that range. Not just your high-profile big cases. Lawyers taking it from their client's fund. 20 years ago it was unheard of to have a client security fund, to have a security fund for lawyers who steal. But we have to have that today. And I've had those in every district I've gone in also, lawyers who take clients' funds.
Okay. And now I can't remember what that third question was going to be.
I confuse people quite a bit. I'm sorry.
With respect to the resources, actually, was related to what Senator Kissel was asking about. One of the things that I noticed last year, I was looking at this in a little more detail, and I had the people from in my capacity as a member of the Appropriations Committee, people would come before us and talk about don't cut our program and that sort of thing. It seemed to me that I remember there were a number of different programs that had beds where there were, like, say, 40 beds in the program, but only 20 of them were filled. because they were in some way or another had an age restriction or something kind of restriction on them. So I got the impression that we were paying for beds in various programs, but we weren't using them at a time when, and I would agree, there is no place to put a juvenile if you can't find a home-based, community-based, where the family puts it together for the system. There really isn't much of anything out there. So if you can't send the child home or to somebody's home, we really don't have much except incarceration, which I don't know what happened to this young lady, but I'm guessing she didn't graduate from high school.
You're right.
Which is already a major setback in her life because she couldn't do that. So no matter what happens after this, she's going to be, playing catch-up if she can. But it seemed to me that there were more spots, but somehow we'd put a label on them, which basically prohibited you from using them.
Correct.
And that's not just my or my.
No, they're categorized. You're right. They're labeled for certain people. Parole may have some. Then we have some going for in our New Haven area where they can't be really utilized from, say, the Waterbury or Hartford district, and the beds are just lying dormant there. You're correct, sir. Okay,
because I think the financial problem is here, and we have to find some solutions that are more creative or maybe re-examine some of the choices we've made in the past about labeling and identifying, well, this is only for one section of the state, because there are needs in other places that could be satisfied with some of these resources that we actually do have. Okay, thank you, Your Honor.
Thank you, sir.
Okay, we got Representative Dillon and Gonzalez and Representative Walker and Senator Gomes. Representative Dillon.
Thank you very much, Your Honor. I'm Representative Dillon, that lady. Congratulations on your reappointment.
Thank you very much.
And I guess I wanted to ask you about the number of cases you see that are drug-related and how we handle them. I don't know if you remember this, but you and I attended a conference in Boston on drug courts.
That's right.
That's right. With Judge Donnell, and it was way back in the days. We were very excited about making changes, and I know that you were deeply involved in the drug courts as they were structured in the beginning, and later they were modified. And it seems to me, I don't know whether we're doing this right or not. It seems like it's costing us a lot of money, though. And can you estimate, like how many of the cases you see where you would think, somebody does something wrong, that's one thing. And that's absolutely accurate. But let's say possession or things that are absolutely driven by addiction, and how you think it influences the court.
I would say 70% or 75% of our crimes are drug-related, either directly or indirectly. Most of the robberies we have are people who are on drugs. Most of the burglaries we have, people are on drugs. Then you have your direct drug offenses, possession of narcotics, sale of narcotics, or whatever. Now, you were talking about we changed. I know that the drug courts in Connecticut, because they were not profitable or weren't getting your money's worth, they were disbanded. In New Haven, we still had the drug intervention unit, and it's still there. Right. And I could tell you that when I left last year, we probably had about 90 people in that drug intervention unit. These were people who should go to jail. They're on probation, they have a lengthy criminal record, but they wanted to stay out of jail. So we have Grant Street in New Haven, we have Crossroads, there's Project Moore there, and these people would end up pleading before me with a cap, X amount of years in jail, and I would watch them for a year. And it costs us about $6,000 a person as opposed to $50,000 to put the person in jail. And we have about a 65 to 70% success rate of people making it the entire year. And it's not just, it's treatment, find them a job. So when they come out, the chances of them being a repeat offender have now dwindled somewhat. I still think that's the way to go. I'm not afraid to put a person in jail, but a person who's on drugs, and the criteria for the drug court was no sex in their history, sex offenses, no guns, and no violence. Out of that, these people, if you corrected their drug problem, got them a job, they could become good members of society. So people have forgotten about this now, but I still think it's a good way to go. Cost saving right down the line. You're saving $44,000 in inmates. If we have 100 people and we graduate, let's say 80, it costs us how much? $480,000. And what do we save? We probably saved a couple of $1 million.
Well, see, I guess in my view, I mean, I was separating out, let's say, a robbery that may be drug-driven or addiction-driven, but you're still accountable for your actions to a certain extent versus someone who's in for repeated possession, violation of probation. And a lot of those come back on technicals, I expect. Yes. How much, where there's no harm to another person involved, you know, but it's a very clean or very dirty possession, sort of. There's no other action that you can say was created by it.
Percentage?
Yeah.
About 35 to 40%.
35 to 40% of the cases?
Yes.
And would you have any sense of the way that that we're handling them now, things that we could do in the legislature to make it better? I mean, it's obviously we can't create jobs for folks who aren't addicted, much less people who are, you know. But
it comes down to what Senator Kissel was saying. People come back on a technical violation. It's very easy to have a hearing. They owe 6 years, we'll say, in a possession charge, and now they get caught with drugs again. So you have your hearing, you give them 6 years in jail, and you forget about them. Right. That's not the answer to the problem. Mm-hmm. If you have the person admit their violation before you, and now you find another treatment program for them, a more structured. If it was outpatient before, now it has to be inpatient. Mm-hmm. And you know, these 30-day wonder programs don't work. It's got to be 4 to 6 months at least. They go to Crossroads for 6 months and they stay clean. I put them back on probation or terminate their probation because now they have a chance to make it. The problem is resources for these beds. The money's not there.
Senator Gonzalez?
Good afternoon, Judge.
Afternoon.
I'm not going to ask you your age.
Question 25. Go ahead.
I'm not going to ask you your age, and I'm not going to mention your age either.
That's why.
Okay. I'm not going to say. I'm not going to not even mention.
Thank you very much.
But my question to you is not even question 25. You see, my question is that if you have a juvenile in your court, and that juvenile need, let's say, extra help, would you think that there is some professional or to walk an extra mile for that? Juvenile? What's your opinion about that?
Well, see, is a juvenile, you mean a 14 or 15-year-old? Because those people in the adult court are there for a serious offense. They were already in juvenile court, and the case was transferred to the adult court. It could be a robbery 1, a burglary 1, a burglary 2, or an assault 1, or a sexual assault. Okay. If we're dealing with the youthful offenders, before you had raised the age to 16 and 17-year-olds, who don't have, it's not a violent crime, judges will go out of their way to find some resource, either through the bail commissioner's office or probation, to hopefully correct that young man or young woman so they don't come back and be a repeat offender.
So that's doable, and some judges say do that.
I would say to most judges would do it if we can, we would do it, because you don't want to throw a young life away.
Thank you.
You're welcome.
Thank you. Good afternoon. First of all, I want to know, what Home Depot do you get handcuffs in?
I'm sorry. you know, after I said that, someone came to me and said, they don't sell handcuffs at Home Depot.
No, they don't.
I had no idea.
Oh. I was just wondering where you were shopping. I wanted to know. I want to kind of continue with the discussion that you were having with Representative Gonzalez. At what point do you make the determination on whether to send a child, let's say a 16 or so, a youthful offender, to jail versus sending them to trying to get them services or getting other services or things that are going to help them?
If it's a violent offense, a robbery with a gun or a knife, the only place is jail for them, in my opinion. If, in fact, you're dealing with a nonviolent crime, drugs, even a burglary into a car or to a warehouse or something like that, then I ask the bail to try to find what programs we have available in the area, and then I'll put a bracelet on them with a curfew. A parent is there. They have to go to the program. They have to be in the house at 8 o'clock at night, obey the rules, respect their mother. If they're in school, continue on with school. If they violate one of those conditions, then I raise their bond for a weekend and then let them go back again. If they violate again, I raise their bond for a week and then 2 weeks. And that's what I try. And if they keep as a repeat violator, then you have no choice but to put them in jail.
When you're up to the point where you're sentencing and you have people come and testify for the let's say the youthful offender, how much do you weigh that when they come up? Let's say the minister, the school teacher, family members. How much do you weigh that?
If a person pleads guilty on an agreed upon sentence, whereby the lawyers and the state have worked out an agreement where you're going to plead for, let's say, 4 years in jail, it's an agreed upon sentence. So I don't listen to I listen to the people. It plays no part in my sentence. If it's a right to argue, of course you listen to those people. And you read the pre-sentence investigation report, and you have to weigh everything together to come out with a sentence that you feel is fair and just for that one individual.
I guess, but I've been in some of the courts, and people have come to testify on behalf, and in fact, I've done that too. And I think it would be worthwhile to know that people are coming there to try and defend the person, to say this person has an opportunity to make a turnaround if they have some faith. But if they knew that whatever they're testifying about is not going to have an impact, didn't you think do you explain that to them in the beginning when they started?
Well, you know, I usually keep Fridays as my sentencing day. The lawyer will come and say, I have about 10 people to speak on behalf of my client. And the state's attorney will say it's an agreed upon recommendation. And I'll say, if it makes your client feel better to have the people speak, fine. But I can't change the deal because it's a contract. The state and defense have made an agreement for 4 years. If I went under that 3 years, the state may have dropped some other charges. They'd reinstitute those charges. So I'm up front with the people. And some lawyers will say, well, my client will plead guilty if he can have a right to argue. I said, my mind is 99% made up. I'm not going to mislead your client. I go on the record and tell him that. But if it's a right to argue, I listen to everybody.
Do you always explain to the defendants about youthful offender status when they come before you, if they are 16 or 17 and first-time offenders?
Well, as far as, from the bench, no. What I do every day is pre-trial cases. And so when the case comes to me and the person is 16 or 17, we explore youthful offender status. We explore a sentence to structure to try to help that young individual. If they're not in school, to go to adult ed or whatever. So I don't tell them directly from the bench, but we do talk about it in chambers with all counsel. Okay,
but I guess my question is, how do you explain it? You do explain it to them in the pretrials?
Oh, if we're going to do the youthful offender, when I go on the bench at that point, then I explain it to the individual young person also, yes.
The other question I have, let me see if Mr. Kane is in the office. He's out. Good. One of the things that I had always questioned and asked about, and I meant to ask other judges, what do you think about, we rotate judges and we rotate public defenders, but we don't rotate prosecutors.
You don't rotate public defenders.
Well,
no,
we don't.
They're there.
No, but I mean, they get moved around from court to court. Most of the time you have prosecutors are the ones that are the most stable. Public defenders I've found in different courts, moved in different courts.
If you have a public defender on the Elm Street Courthouse in New Haven,
right,
they may change jobs. If a Part A opened up in some other district,
okay.
It's not automatic. As far as judges, every year we have to put in a request where we would like to sit and what type of cases we want to sit on.
Okay.
And then the chief court administrator makes up his or her mind what they decide where you should go. But as far as public defenders and prosecutors, they're stuck to a certain area, and unless they move up as far as an elevation, they stay there.
All right, then what would you think about having public defenders and prosecutors being rotated as often as judges?
I'm not really that in favor of judges rotating as much as we do. You know, I'll tell you why.
Okay.
What I do is, I said, I pre-try cases. So I leave New Haven after, say, I was there 5 years. Now I go to Waterbury. It takes me about 4 months to get up to speed on the cases that are there, to get to know them. And then in a year and a half after that, I move on to another area. And again, I go through the same process. It's much more efficient where you have one person, you know the cases they come in, you know the defendants. So, but I would be against rotating prosecutors and public defenders, but again, that's none of my business.
No, I've just, a lot of times the familiarity of the prosecutors with the judges and the public defenders sometimes is a good thing, but sometimes it seems like there's almost a bond between them, and whoever is in court is sort of not the main focus. It's the relationship that goes on there. And sometimes I think that intimidates the people in there.
I'm not a very friendly person, so I don't bond with many people. But you may be right. You may be right. It could have its disadvantage. Yes.
You do have a long history. Well, then, can you tell me about judicial temperament? What do you think judicial temperament is in the court for a judge?
I hope I had it for the past 24 years, but it's listening to people, giving everyone a fair shot to say what they have to say, not interrupting, not losing your temper, putting aside any biases you may have as to anything, and just being fair and open-minded and just willing to listen.
Thank you, Judge.
Thank you.
Senator Gomes?
Yes, sir.
Good afternoon, Judge. We're having a pretty good dialogue here. I don't mean to throw rain on your parade, but
It's okay.
You asked Representative Gonzalez if she wanted to answer the question number 25.
Yes, sir.
Well, in here it says, have you have a complaint ever brought before the judicial review? And you said yes.
Yes, sir.
But you put on here, I see appendix B1 to B10, but there's no B1 to B10.
No, they were attached.
You do have it?
They were attached.
I don't have one. He didn't have one.
Oh, I'm sorry. The secretary made copies, and they all should have gone out, even with the memorandum, C1 to C5.
In fairness to you, I'll read it before I say anything. I just wanted to read it, that's all.
I could tell you what it's about. The people who complained about me said that I gave them too much time in jail. I was discriminatory towards men by putting them in jail. One individual, John Mealy, he was in our drug court, and he broke the drug court contract, and I put him in jail and wouldn't put him back into a program again. That's about it. I know Representative Gonzalez thinks judicial review just rubber stamps dismissals. I had one person, this goes back maybe, 15, 16 years ago. In Waterbury, he was filing a complaint against me every week. He had a mental illness. He even said I made him go before a jury, before a judge and a jury, picking a jury in prison garb. I had got a transfer. I wasn't even that judge. My wife got so, because you have to go down to the post office to pick up the mail. She got so embarrassed to go down and pick up the mail every week for about 8 weeks in a row. Certified letter I had to go pick up, and I knew it was from that guy, Clifton Powell. But no, my complaints were all by people who I put in jail who felt that I gave them too much time in jail.
Well, I wanted to hear about it, but I didn't hear. But seeing the people that did have it, and they read it, they didn't have a question, so I don't either. I'll concede to the rest of them.
Oh. Thank you. You want to look at it? Good. Thank you, sir.
Are there any other questions? Senator Coleman.
Thank you, Mr. Chairman. Good afternoon, Judge.
Good afternoon, sir.
And congratulations to you.
Thank you.
Let's see. Being familiar with your vast experience in criminal court, I didn't want to waste an opportunity to present some of my concerns to you, not about you in particular, but about the criminal justice system. And what I have to say probably applies more to the GA courts than the judicial districts. My observation in judicial districts, I think there's volume, but it's not the press of business that may occur in the JA courts, particularly in Hartford and New Haven. Probably less familiar with Bridgeport, but I imagine Bridgeport is probably similar to what occurs in Hartford and New Haven. But at least what I observed at the